Pavithri, please do a brief introduction because I'm going to share this recording with some folks.
Okay.
That need the info.
Hi, everyone. I am the owner of KPSK Consulting. We provide comprehensive HR consulting for small to medium-sized businesses, focusing on employment and labor law, risk mitigation, compliance, and developing HR policies and procedures. More importantly, we focus our work around government agency compliance because you're more likely to get a government agency showing up before a lawsuit coming up. And we want to make sure our clients are very well protected from any kind of audits and is able to defend themselves against the government agencies before they have to worry about any sort of litigation. We provide fractional services so that our clients don't have to pay for any full-time services, and we will be their HR department as needed. So there's been a lot going on in the last few weeks of the quarter because a bunch of stuff happened in 24. We know some things are changing in 25. And then based on the people that registered, I put the 4 states that were registered. So otherwise, we still have time for Q&A, so I'm not even worried about it. All right, so guess what? Women finally have some rights in this country, federally. So the Pregnant Worker Fairness Act went into law, as well as the Pregnant Discrimination Act, right? It's finally, we have discrimination in employment for that. And then you have to, as an employer, make reasonable accommodation for known limitation of employees and applicants during pregnancy, childbirth, and medical conditions. Pregnancy Discrimination Act is any kind of disability and that could be temporary and or perceived during childbirth or after that you would need to accommodate. So biggest thing that came is, I don't know if anybody knows or remember because I am a geek. There was a case against UPS that against a pregnant driver sued UPS because UPS told her she could not work at UPS while she was pregnant. And her argument was people on workers' comp are able to have light duty and work at UPS. Why can't I? And UPS basically said it's too dangerous. So long story short, UPS got sued and she won because you have to treat pregnant women the same as you would any other employee and work through the interactive process to see what is and is not doable for them and work with their doctor and not just go one size fit all. Let's see. The Pump Act. The 22 Pump Act basically filled in a whole lot of holes from the original 2010 law, but there was a delay in full implementation. So everybody is now covered with the exception of flight attendants. So it protects workers nationwide. State and local laws that provide additional protection are not changing. Clarifies that the pumping time counts as time worked when calculating minimum wage and overtime, if they are not completely relieved from work, as in if somebody is in the nursing room, still answering phone calls or whatever the case may be, that is work time, not free time. It doesn't matter how many employees you have to accommodate up to 1 year following the birth. And the pumping space cannot be a bathroom. Pretty please. By the way, the same applies for diabetics who have to either test their sugar and or take insulin. The safe space for them to do either of those things is also not the bathroom, just so you know.
Mm.
All right. After a long time, the EOC actually changed their harassment guidance from just sexual harassment to very broadly include sexual and other harassment. So the new guidance replaces the 5 previous guidance documents and covers harassment based on all of the protected categories and includes medical conditions, sexual orientation, and gender identity. And where GINA, Genetic Information Non-Discrimination Act, was separate, they have now moved it into part of the harassment for genetic information. So that's like the big changes that came through. So harassment becomes unlawful. That standard has not changed. So in order for somebody to prove harassment, they have to be able to show that the conduct is continuing, a condition of continued employment, and that it creates a work environment that is pervasive enough that they can be considered hostile, intimidating, and abusive. So that's the legal standard somebody's got to meet. I know some of you on the call has 1099s versus W-2s. And what I will say to that point is harassment is harassment is harassment. It applies to employees, vendors, contractors, all of the above. If they touch your business, it impacts. So it is in your best interest to make sure that you are on top of what these look like. Because if you're not protecting anybody in the office because they're 1099s, you're still SOL. So, and if you don't know what that means, there's somebody else. All right. So, if you guys were on my call, I don't know, beginning of the year, the DOL changed how they define a independent contractor versus a employee. Okay. They replaced the 2021 rule, and now they have a 6-step test you have to take. So does the individual have a opportunity for profit or loss depending on the managerial skill, investment by the worker and the potential employer, degree of permanence of the work relationship, nature and degree of control, extent to which the work performed is an integral part of the potential employer's business, and skill and initiative. Additional factors may be relative, but that is a little bit more of a gray area. The DOL is very focused on small businesses when it comes to looking at misclassification at small businesses, because that is where this happens the most. And home health care and construction are the 2 industries they're really focused on right now. And the rate in which home health cares are getting shut down is like ridiculous. And I think, Brandon, you guys are probably seeing a lot of that industry coming through school.
But one of the things we're seeing it with home care, non-medical home care, a lot in terms of therapists who are in private practice who have engaged other therapists that have always been independent contractors, and now they can't, and they're just not set up.
So yeah, I was gonna say, in certain instances, the therapist world can have the 1099 piece, but it needs to be very closely vetted. But on the home healthcare side, it cannot. And it also needs to, they're forgetting a lot of times that travel time is paid time in home healthcare. So, and then this is going to change the landscape in that a lot more people are going to be considered employees, and they're going to have minimum wage, overtime, and other benefit considerations. So as we're planning growth and all of that for your company, you need to make sure that you're taking those things into consideration. And because I am so nice, let's talk about the consequences. Misclassification has serious consequences, right? So fines and failing to file Form W-2s. And oh, by the way, that's with the IRS, and that's up to $1,000 fine and up to 2 years in jail, for instance, just saying. Withholding taxes, paying matching FICA taxes, civil fines, criminal penalties, debarment from government contracts and court orders. So what's happening with a lot of these healthcare companies that are getting shut down is the court orders to pay back what they owe the government as well as what they owe the employee are literally bankrupting these companies. So that's where you need to be super careful on how you are doing it. Any questions around that? Okay. So go ahead.
Pavithri, can you go back one? So how can you tell? So that's always been a concern of mine. You and I have talked about this a number of times.
This or the 6-part test?
Let's go to, well, this is very scary, but if you go back to the 6-part test, so how do you tell? How do you know if you're misclassifying? Like what's the litmus?
Yeah, I'm trying to figure out whether there we go. Okay. Litmus test is if any one of these things are a yes, they're an employee. Right? The easiest way I can say is I'll use me as an example in this, in that, do they have their own company? Are they running off of their social security, or do they have an EIN? Are they working just for you, or do they have multiple employers / clients?
Okay.
Do they have the freedom to work on their own schedule, or are you dictating how and when the work is done? And lastly is, do they use your equipment to do the job? And are they on your site doing the job, and do you require them to do that? So that's like the easiest way to look at that in what that work relationship is. Does that help?
Yes.
Okay.
Yes. Makes me feel better.
Okay. All right. Okay, so for individuals that have W-2, I don't know if you guys heard, but the Department of Labor, after about almost 30 years, finally looked at the salaried employees numbers like they do to hourly employees and minimum wage. So basically, they raised what a salaried employee can get paid, but there is an exemption for what's called the highly compensated individuals. In order to do that, you need to have paid a salary, predetermined, fixed amount, nothing changes day to day, or pay period to pay period. Has to be a very specific minimum salary per week, and then primarily be performing executive, administrative, or professional duties. So they have a separate test to figure out the highly compensated employees who are paid a salary earn above a higher total annual comp level and satisfies the minimal duties test. So let's get to the numbers, because that's where everybody wants to know.
Can I ask a quick question?
Yeah, absolutely.
So if I look at that, when you have, for instance, therapists who are working together, either like occ health, social work, psychiatric, obviously they're professionals. If there's a situation where they are not salary, they're guaranteed a minimum salary, but it's really an hourly rate, would that still meet these requirements?
If they are not paid as a salary and there's any variable from pay period to pay period, they are non-exempt hourly. They are not a salary employee.
Okay.
And once you see the next slide, you'll also understand why you probably want to keep them salary. So before July 1st of this year, all you had to do was pay somebody a little over $35,000 to call them salary. July 1st, it became $43,888. January 1st, coming up, it's going to change to $58,656. If you do not pay somebody a minimum of that amount, they are not a salaried employee, they're hourly. And that has to be the base pay. That is not a accumulative of salary plus bonus plus reimbursement plus whatever. That is the minimum base pay an individual can make. And then after that, in 27 and every 3 years after that, they're going to be applying the data and looking at salary levels with inflations and see about changing those and updating. So this is another way to making sure that employees are classified properly. So just like you have penalties around misclassification from 1099 to W-2s, you get the same thing from non-exempt to exempt. So whether you have somebody hourly or salary can also be considered a misclassification. Questions on that before we go into the other just noteworthy stuff? Good, cool. All right, FTC banned non-competes. And on that same topic, they got shut down. And we all kind of knew that was going to come, right? Basically, one of the, I want to say it was the Fifth Circuit, came and said that the Congress did not give the FTC power to regulate non-competes in this fashion. So non-competes went back in play. For those that were hoping it went away, it doesn't. All right, religious accommodation. This changed in how an employer can see undue hardship in denying a religious accommodation. Undue hardship as is before this ruling was almost impossible to meet. But small businesses had somewhat of a little bit better leeway on that. This basically puts you in a spot of like, unless it's going to shut your business down, you don't have an undue hardship. So be very careful how you go about it. Take a partner and vet it, make sure you're doing it right. I-9s. The new I-9s went into play October of 23. And we are still finding a lot of companies still using the old I-9s. So if your I-9 does not say that it expires in 2026, you need to go on this link and download the new forms. Also, if you have remote employees and you are verifying IDs remotely, you must be enrolled in E-Verify. It's free, it's a government service, but if you don't do E-Verify, you cannot legally do remote verification. And then OSHA expanded the injury and illness reporting requirements, and this is very industry specific. And Andy, I think you're the only one this is going to impact from a work perspective, most likely. So I won't go into too much detail, but everybody else is mostly professional work only. So any questions on the OSHA 300 or anything like that? or any of these at all?
I didn't realize the non-compete came back into play. I didn't hear that.
Yes, you did. I emailed you.
I mean, yeah, I knew all about it.
Thanks for playing.
Sorry.
So nice to know people actually read my emails. My clients,
Read
ladies
those?
and
I thought
gentlemen. I'm
we're-
sorry?
We're supposed to read those?
Hey, I do my duty and email all my clients all the updates. Whether you read it or not is on you.
Mm.
So, all right.
There you go.
Any other questions? Don, you came off of mute. Did you have actual question? I'm guessing that was a no. All right. I put this in there because I know this impacts at least one of my clients. Enhanced gig worker protection. So new regulation extends the protection to gig workers, including minimum wage guarantees and access to certain benefits. So make sure we are reviewing the classifications, update the policies if we need to, and then budget for potential increase in operation cost based on that. 2025. Any idea what's going to happen? Yeah, guess what? Your guess is as good as mine. Most of the government agencies will be changing leadership with the new administration. Almost all of the heads of the federal government agencies are political appointments, including the National Labor Relations Board. I'm sorry, let me rephrase. Excluding the National Labor Relations Board, because they actually will replace the entire board versus just the head of the board. If you don't know what the NLRB is, that is the agency that governs unions, not just for union shops, but also for private employers who don't do unions. So I have no idea what the new focus for these agencies are going to be and where they're going to put that focus on, employees, what size, classifications, all of that. What I can say is a little glimpse into the past, right? We already had 4 years of this administration, so we have a little window to say, this is what it might be. So like in 2020, the executive branch made it illegal for the EEOC, the Equal Employment Opportunity Commission, to do anti-discrimination training for companies. I mean, it was great business for me because I had the EEOC referring some clients towards me to go do the training. But you get my point, right? All I can say is just stay tuned. You guys are, all my clients and everybody are on a auto mail list for me. And as soon as I have updates, I send it out. So just make sure that whatever changes comes, I will be emailing, and Jeremy and Lisa will make sure they listen to it or read it.
I always listen to you. You're so important.
You are so full of,
Be nice.
I know this is recorded. I'm being nice. All right. Any other questions around what we have no clue is going to happen in life? No? Good. All right. I'm going to skip through Colorado because my Colorado people are not on here. So, and go straight to Florida. Employing people with disabilities. Employment First Act. It's going to be at some point asking you to give reports around employing individuals with disabilities. Then there is the heat exposure. Florida previously had no statewide requirements, which I don't understand. And there is no state agency in charge of OSHA. Again, I don't understand, but OSHA is still under federal jurisdiction and covers most of the private sector workers within the state, and does not cover state and local governments. So what this bill does is basically prohibits counties or municipalities from creating their own heat exposure requirements for employers. Instead, the state will have the sole authority to determine standards. Counties or municipalities may establish heat exposure requirements for their own employees. Woohoo. And then it also prohibits political subdivisions from maintaining a minimum wage other than that set by the state or federal minimum wage. So if you're in Florida, you got lots of fun stuff happening. Teen labor rights. Yeah, there's a lot. They removed a lot of restrictions, but they did put a lot of imposed restrictions around when they work, when there is school scheduled the next day. Teens aren't allowed to work more than 30 hours in a week when school is in session, but they can work whatever they want when school's not. Teen labor rights and education. It does allow 16 and 17-year-olds to work in some aspect of home construction under supervision. And then there's also Florida is allowing more employment opportunities for teens and avoid penalties and all of that lovely stuff. And Julia, I'm sorry, I think I just gave your dad a lot of permission I shouldn't have.
I was supposed to ask, what if they're out of school? Everything's fine, right?
I'm just going to keep going now. Minimum wage is expected to go up to $15 by 2026. So again, if you're going to be having W-2s, make sure you're keeping that in mind as you're doing your budgeting. There is no state-specific overtime laws in Florida, but so you must follow the federal. Florida doesn't also have a reporting time pay, meaning if an employee has to come to work and they get sent home early, you only have to pay them what they actually work. Most employees are required to have workers' comp insurance in Florida. The rate is varied, but it is calculated on the first $7,000 for each employee's wages. So you don't need to worry about some other states where it is full payroll that takes into account. You can do better calculations in Florida because it is the first 7,000. So if you have 10 employees and you know they're going to make more than 7,000, you know you can calculate your workers' comp at 70,000 on a payroll. Does that make sense?
Mhm.
Mm-hmm.
So there's a reemployment tax, formerly known as the unemployment tax, expanded its anti-discrimination laws to now include discrimination based on vaccination status. Also, the Florida Stop Woke Act that Governor DeSantis signed in 22 was aimed to restrict workplace training and educational discussions around race-related topics. Court did issue a permanent injunction against the workplace training part of the law, stating that it violated the First Amendment rights by restricting free speech. Questions, comments? Good. Oh, Indiana. Okay, so Indiana has a new law, which kind of boggles my mind because they don't always come up with these lovely things. in Indiana now, you have to do a new hire reporting. So it needs to be done within 20 days of the date of hire or reemployment and must include all of these lovely information. It can done electronically. If you don't want to give all of that, you can give their new hire reporting form or a copy of the W-4. So this law's in the books. So anybody you hire going forward, W-2, you need to do this. Again, when I send the PowerPoints, you'll be able to get into these links.
Is this already in effect or going in effect as of January 1?
Already in effect.
Okay, I need to remind some clients of that.
Yeah. This one, again, boggled my mind. Indiana Criminal Records Access. So Indiana private employers need to be aware of the rules and regs, specifically around arrest and conviction records and the access. So generally, employers are prohibited from using arrest and conviction records for any purpose other than those stated in the request for record. Any purpose that would deny any civil right of the person who is the subject of the record. An employer may not ask an employee, contract employee, or applicant whether they have a criminal record that has been sealed or restricted. And then generally discriminate against any person because of a conviction or arrest record expunged or sealed under the law. And then inquiring about criminal record history that has been expunged during any application for employment license or other right of privilege. In other words, only run a background once you know you are going to absolutely hire them, and then only make sure you're doing a full individualized assessment against the job description for which you are hiring them for the whatever convictions you find. Almost always looking at arrest records are going to come back and bite you through the EEOC. Now you got the Indiana Human Rights Commission on top of it. It's not a nice place to play in. So if you have any Indiana employers that need to talk through this, let me know, because the EEOC guidance came out of a EEOC lawsuit against a small company called Pepsi that cost them $12 million. So I want to make sure that all the small businesses around the area is aware of how to avoid this landmine easy. All right.
Okay, Pavithri, real quick.
Yes, ma'am.
I don't know. I'm not even asking a question. I don't think. Today we were in one of our meetings this morning. They had a situation just real quick. And I guess I'm kind of wondering why they wouldn't have run a report or why they wouldn't have run a background check on him. But it was a tow truck company that had a driver that they didn't run a background check, and he got into an accident, and then he immediately left, quit, and they couldn't find him. And obviously they should have run a background check, but
So that would actually not be a background check as much as a DMV check.
Okay, I get
driver record. So it also depends on, are they independently owned, right? So if it's a large dispatch company hiring multiple tow truck companies,
yeah,
then it is on the dispatch company to get the information from these companies that they're contracting to say that all of their drivers are insured, bonded, background cleared. That's what I was telling Phil, like, make sure that the people you send anywhere to do anything is insured and they're able to give you a insurance certificate, because if something happens, you need to be covered. if they're a direct employee and you didn't run background, you're an idiot.
Well, I think actually it wasn't a gigantic company. And the spider web of how it's all connected, it was actually an insurance question because it ended up, they didn't have any, I mean, I don't think they had anything they could do because they'd lost track of the guy. He's literally gone.
Remember, if somebody gets into an accident driving for work, while
Yeah.
you can require somebody to have insurance, at the end of the day, if you haven't done your due diligence to make
Right.
sure that the person you're putting out on the road is actually safe and would not be a detriment to themselves or others, your company can be held liable.
I think that's kind of how it ended up, but it was like the insurance agent, the insurance agent was explaining the story.
Yeah.
And she said, I couldn't do anything about it.
Yeah.
And when you're talking about, obviously I'm thinking, why would you not run a background check?
Why would you not have HR in your business as a small
Right.
business? Because you don't know what you don't know. And
Exactly.
I absolutely love the fact that I connected with Brandon and he's actually here because at the end of the day, I need to get in front of more organizations like SCORE to get the
Right.
message out and make sure you have the right partners in place to protect your business.
Exactly. Okay. I'm sorry. I didn't mean to
No,
detour.
you're good. You're absolutely good.
Kind of came up today and it was just like you're talking about.
Yeah. I mean,
basic
it's very simple, right? 99% of the time when companies get in trouble, it's not because they're trying to avoid doing something. It's because nobody has stopped and told them they need to do something or have something in place. So what usually ends up happening is they learn by mistakes. So
Yeah.
and
I guess
sometimes
the
it's a
other
very
question-
expensive mistake.
Right. So I guess one last question, not one last, but you actually, if you help somebody, you stand behind. I'm not saying you're going to go but what do you?
Yes, I
bring?
am insured and all my clients do get a certificate of insurance that says if I make a mistake, they're covered under my insurance.
Okay.
If I give them advice and tell them what to do and they decide to go do their own thing, my insurance will not cover them.
Right.
And I get to laugh in their face.
I think we could all understand that, but yeah, so that was one, and I don't think I've ever doubted that, but I was just thinking if we don't know and you advise us, yeah, okay. Yeah. Thank you. I appreciate it.
No worries. Indian employers, you are required to do final pay by the next regularly scheduled payday. Indiana technically does not have a unused benefits payout. Then you need to follow what's in your written or oral policies. But I will say this has not necessarily been followed by the Indiana Department of Labor to the letter of the law. So at a previous employer, small business, the Indiana Department of Labor did come back and say, because your handbook did not say that you don't pay out unused PTO, he's entitled to the unused PTO because that's the assumption he would make. So if you're not going to pay out any benefits at the end of employment, make sure it is part of your handbook to take away any kind of confusion. Meal and rest breaks, only if you have minors, because I tell people, start a business in Indiana. We don't care about our employees or our employers. It's a hell of a lot easier to run a business in Indiana. That got you laughing, Brendan.
Sad but true.
Yeah. I mean, we're surrounded by like Ohio, Michigan, Illinois with mile-long protections. And then you got Indiana and Kentucky going, we don't care.
Board, Virginia.
Just for you, Lisa, and one of my other clients, I have Virginia laws in here too. Jury duty leave. This is new in Indiana. They're still not paying employees to go be on a jury, but they have now made it a protected leave. You cannot take adverse employment action against an employee for taking jury duty. However, you have to provide as much notice as you can. You also can't force them to use their PTO. Employee can choose to take it, but you can't force them to take it. Indiana discrimination laws. So federally, the EEOC kicks in once you have 15 employees or more. In Indiana, all of the Department of Human Rights regulations kick in at 6 employees. So don't get complacent because you think federally it's 15, because state it's 6. Also, when you guys get these slides, if there's an underline, it's 99% because there is a link attached to it. And then if you have more than 50 employees, there's new requirements, a new poster went out. So if you don't have it, get it from your payroll provider, or you can download it from the DOL, but it is everything around outlining veterans benefits and services. So that is now need to be included for any company with 50 or more employees. Firearms, weapons. So you cannot do anything to your employees if they have a firearm that is locked up in their trunk, glove box, or out of sight in their own vehicle, firearm or ammunition. Indiana does not prohibit an employer from adopting or enforcing that they cannot have those in certain industries. And if you are an employer who do not want firearms inside your workplace, you have to have that on the front door. You cannot not have it on the front door that says no firearms, no weapons, with the outline of all the weapons you don't allow, and then see a gun and say you're fired. Not an option. Make it clear. Smoking on work property. It is now illegal to smoke inside in Indiana, and you cannot smoke within 8 feet of public entrance. However, Indiana is still only one of 3 states in this country who provides protection for smokers from discrimination in the workplace. So you cannot single out a smoker at work and treat them different from any other employee because they are a smoker. So,
But if they're taking excessive smoke breaks,
that's not, so that is not following their meal and break policy.
right?
Has nothing to do with smoking.
Okay.
Yeah. All right. I'm not going to go through all of Virginia, but Lisa, you'll have access to this. The big thing is like
I'm an Indiana company. Virginia laws don't affect me. I just visit.
Don't you have clients in Virginia?
Well, yes, but
Yeah, so aren't your clients impacted by this?
yeah, but that's their problem.
And my client who's supposed to be in this call that's in Virginia couldn't make it, so she sent me a message going, sorry, so I will skip through Virginia. And
yeah, we can skip through Virginia. I'll read through the slides, but most of them are,
yeah. All right, so I'll go through quickly the Q&A that came up through all right, bye Andy. Call me later and I'll go through anything you need help with. If we can't give independent contractors a company handbook, what can we give them? So I did this answer a little different in what you need to do with your independent contractors. So this is a list of pre-hire documentation you should have with your independent contractors. By the way, if anybody have questions that is going to run late, you're more than welcome to stay because I will stay as long as you have questions. Not a problem. So go through it because this will give you a good idea of, do you have the pieces in place to defend yourself if the DOL says they're not an independent contractor? And then more of the pre-hire, and then we're going to go here that says employers should ask the worker to provide documentation supporting their status as an independent contractor. So what does that look like? If you come and tell me, hey, how do I know you're an actual 1099? Easy peasy. I have plenty of documentation to show that I have a federal EIN. I don't use my social security. I have my taxes filed that shows I am filing for a business and not a W-2. So you have all of those stuff in place that can be produced. And then what can you give? Give them a scope of work. That along with the contract will outline just about everything they need to know without you having to give any kind of handbook. All right, this conversation came up last night, so I decided I have to put this on because, I'm a pain in the butt. So what's the difference between new hire orientation and onboarding? New hire orientation happens once. So it is where you are the first day, get all your layout, culture, handbooks, all the things you do on your first day. One and done. Onboarding is more of the relationship building with new hires. You should be meeting with them on a more of a larger cadence, right? So that you can make sure they're acclimated into your culture and is learning the job faster and is aware of all the roles and expectations. New hire paperwork is not orientation or onboarding. New hire paperwork is still considered prior to employment. Because if the new hire paperwork is not done right, you are not an employee. So this one, I had just made the comment, come on, Brandon, don't give me that. I'm going to lose.
No. I have heard this multiple times.
I was hoping my partner would be on this call, and he is not, because he for some reason remember this. I don't. When he and I worked together like 15 years ago, he remembers a story about a topic on this that apparently I handled. I don't remember this, but apparently we had an employee that owned a chicken farm and somehow would work in the chicken coops in the morning before coming to work. So I'll let you figure the rest of that out. And I don't remember any of this. So every time this comes up, his first thing is, talk about the chicken coop. I'm like, dude, I don't remember the damn chicken coop. So I had told Jennifer, I will answer anything from legal to how do you deal with smelly employees? And Jennifer was like, I want to know the answer. So I had to put it in there. Approach them privately. Okay. Explain what you've noticed and ask them to take steps to improve the personal hygiene. What I will add to this is very simply, make sure you have somebody of the same sex in the room with you if the employee or contractor or vendor or whoever is not of the same sex as you. So, key points: privacy. Be direct but tactful. In other words, don't be like Pavithri. be nice. Focus on the impact. Don't, personal feelings have no part in this conversation. And then offer solutions. Long time ago, before employment law and HR became actually a enforceable thing at work, I used to have a manager who would go around with a razor blade and a deodorant and walk up to the employee, shave the top, and say, "You need some." And I'm like, dude, you cannot literally do that. So please don't be that guy. And then you should have company policies that talk about company appearance, right, at work, that should have a line about proper hygiene and how you show up at work. So there you go. All right. Let me do this. So the rest are all kind of Q&A of FAQs like I usually get from clients and stuff. But let me ask if you guys have any before I jump into any of these.
I was actually hoping on the last question that I could put somebody on the phone with you, Pavithri.
Absolutely.
I mean, if it comes up, I mean, I understand, and I thank you for dissecting it. I guess I'm always wondering if you run into something like that as an employer, how do you, obviously what you just detailed out there is the answer, but I'm literally like, I think that's almost the problem. Not a problem, but that's the thing that would be really tough for me is,
Trust me, I'm very good at doing my job because I'm willing to have the conversations most employers are not.
Yeah, because I mean, I'm joking around about calling you, but it's almost like, you're like, I can't believe, like I said to you yesterday, briefly, I'll say it real quick. We have a guy that's a young, good-looking guy in our church, and I don't know if he's ever using deodorant. And he's just like, what are you doing, buddy? But he's not my employee. So it's kind of, you know what I mean? Kind of do you say something? Obviously, we're talking about an employee relationship. So didn't mean to take away from that, but I mean, literally, I think this is of course the human, being tactful and being kind and all those kind of things. But still, like you almost think somebody has to shake them to make them, realize they're stinky. So anyway, thank you.
Pavithri, does that responsibility or the most appropriate to address it, is that the hiring manager or the direct manager or HR or who?
Honestly, it is whoever is comfortable, right? If it should never be the hiring manager, because at the end of the day, if the hiring manager is not the one managing them on a daily basis, they have no relationship outside of them getting hired. So it should either be the manager that they report to on a regular basis, that they have a relationship with and would be more comfortable having that conversation, or HR. It should never be a person of authority that they have no relationship with, because you're already starting the conversation in a defensive position by the employee, and it's only going to go south. If that helps. Does that help?
Yeah.
Cool. All right. I will jump into Q&A since you guys will get all of these with the answers as well on if you have any specific questions.
Yep. I got a question.
Yes, ma'am.
Back when you were talking about the background checks, and you were saying that the background check should be utilized reasonably based upon the expectations of what that employee is going to be doing.
Mm-hmm.
So what's like the case of something being found in a background check that shouldn't be used to? disqualify?
Okay. Let's say somebody has a felony for, I don't know, give me a felony. That is not super crazy. Carrying a firearm.
Okay.
And they're getting hired to work in a warehouse. Is there any relevance other than making sure the guy doesn't bring a gun to work?
No, other than making sure that he doesn't bring a gun to work.
Yeah.
So
It's individualized assessment, meaning you're looking at what the felony or what the conviction is and looking at the job description and saying, does this show a behavior that would be a danger to themselves or others in the workplace? And then having the conversation to say, hey, willing to give you a chance, you can't bring a gun to work. On the flip side of it, had a guy who had a crap ton of convictions for prescription drug use and distribution. We get the job description from the client, and all it talks about is warehouse experience. Now, keep in mind, this was in staffing. So we're looking at the convictions, we're looking at the job description, we're like, okay, no issue here, totally fine. We pass him to go work, only to find out the client is a pharmaceutical company. I'm like, guys, kind of useful information, right?
Yeah, pretty
So
important.
no two convictions and no two job descriptions are alike. So you want to make sure that you are looking at it in a very, very isolated situations. Yes, sir.
If you have brand new employers just starting, maybe 1-2 employees max, what's the one thing that you would tell them to do before January 1st?
Get their policies and procedures in place, get a proper payroll system in place, and check their compliance. Yeah. Sorry, there's no one thing, because if they don't have the 3 things in place, they're starting behind, right? So payroll is, I would put it number 1. And while QuickBooks can do a good job of payroll, I always recommend using a payroll company that does the tax filing for you, because they own the liability on anything going wrong.
As a QuickBook Pro advisor, QuickBooks sucks as payroll. Don't use QuickBooks Payroll. And I can resell it, and I say that I don't like it. So
You said policies, payroll, what was the third?
Compliance, right? So employers so let's talk about just the posters. We have a lot of employees now working remote, and you're required to have these posters up. What do? If it's a remote employee, you are still required to email them these posters so they know their rights. Just because they are not reporting to a physical building and seeing it does not mean that you are no longer obligated to do that. So, and Brandon, if they need help with policies and procedures, let me know. Yeah, the biggest mistake a lot of employers make in the small business world is they will go on the payroll companies and will buy the HR suite and download the handbook, which is great. Here's the problem. It's all federal laws. There is nothing in there for you to include state regulations or company policies and procedures. So you get a nice handbook that covers all of the federal regulations that you have to follow, just nothing around your state or your company.
Good. Thank you.
Yeah. I have a couple of really good payroll companies I partner with for small businesses. So again, I'm happy to help anybody who needs help with any of it. Anybody else? Good.
All right, I have a question.
Yes, ma'am.
Kind of going back to the 1099s and what can, you don't give them a handbook. I get that. Do you give them? And going back to the classifications, because this worries me because I've had some people who consider themselves an expert say that I'm walking a tight line. I have you that tells me I'm okay. I trust you more than I trust them, to be honest, but it still worries me.
Yeah.
Well, here's my thing. So when I bring a new 1099 on, we sign a contract, and in it clearly says you are not an employee, you're a 1099, you don't get benefits, blah, 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 which has been reviewed by a lawyer and has been said is valid.
Can I double check and ask because I can't remember if I asked you this question, has that contract been reviewed by your attorney since March 11th of this year?
No, it has not been reviewed this year.
Okay, so that's your step one.
Okay, I can do that. That's fine.
That's when the law changed.
Okay.
So what you need to do is ask your attorney, hey, based on the new regulations, does this contract still stand?
Okay. Oh, I have to get a new attorney because mine's spending too much time on the golf course. He's not in the office enough. But anyway, my second part of that, the part that they always tell me that I am walking the line is in their contract, I say we use a time tracking for our client billing and I can basically do their payroll and pay them based on that, or they are welcome to send me a bill. I have yet to have one send me a bill. And so my accountant tells me that I have to be careful with that because it means that I'm calculating what I pay them, not whereas a 1099 truly should be billing me.
Lisa?
Yes.
Can you breathe for a second?
No.
Okay.
Go ahead.
You are truly hiring independent contractors that work for other companies. They do not work for you. Does that make sense?
Well, but the key, okay, hold on. The people I'm hiring right now, none of them work for anybody but me. Now they can. I don't have any problem with them.
No. I'm saying they're placed for your clients, not for you. You hire them for your clients.
No, not all of them. They do client work, but they don't report.
Yeah, that's what I mean.
They report to me.
Okay, you're missing my point. You are hiring them for working on client stuff that are going through your company.
Yes.
Right?
Yes.
You're giving them options on time tracking.
Yes.
I will need to do a deep dive audit with you, Lisa, but I still stand by based on what you're doing, you're okay.
Okay.
Because at the end of the day, you are still providing an outsourced job. But if you're concerned, we can sit and do a deep dive.
It just means if I get audited, you have to go to the meeting with me.
What else is new?
All right. Thank you.
I will go to any audit and help you guys with that as long as it's not the IRS. I don't do numbers, and that's why I do law. Sorry. Any other questions?
What are the gray areas?
All of it. I mean, that's the definition of employment law. Here's the thing, it's like, it is written in black and white. It is interpreted by most courts and government agencies. And my job is to figure out the loopholes. That's why I tell all of my clients that, hey, I want to have a meeting with you every single month because I need to know where you want to go and take your business to. Because if I know where you want to be by end of next year, I will make sure you get there from a business perspective. I won't be able to get you A to Z straight line most of the time, but I will find you the path to get you from A to Z where you get to avoid all the landmines. So that's why I say everything. It's a matter of knowing where the landmines are and how to avoid them. I know that didn't answer your question, did it, Dawn?
It just makes it feel like owning and managing a business is just really hectic, really confusing. But it's good that there are professionals like yourself who are a lot more familiar with the regulations and requirements and best practices and have seen it, sized it from different, directions.
Here's the thing. It's like, unfortunately, being an entrepreneur is not going to get any simpler.
Yeah.
As the world grows, it's going to be more and more complex. But you also are starting to see a lot more resources available for you to get those expertise to help you manage it. So where you used to have a company get started and have nobody to help them, you now have access to a lot of people. The SBA has offices all over the place. SCORE is everywhere. You got help.
Uh-huh.
So in that sense, I think the newer companies are better equipped than they used to be.
Cool.
All right. I know I've kept you guys after.
Thank
Nope.
you.
Good stuff. Good stuff.
Thank you. Pavithri, I'll send you the link to this tomorrow.
Yep.
Yeah.
And I will clean up my notes and everything and have these out to you guys tomorrow.
Thank you.
Thank you. Tomorrow, sometime over the weekend. Jeremy, do you have any questions? Or are you good?
I'm good. This was very, very engaging. So this was fantastic, and we will take this and make amazing content out of
Thanks, Julia.
it.
Because when he says we, he means Julia.
Yes.
Exactly.
Nice to meet you, Julia.
It's me. I make content.
Exactly.
We've heard a lot. We've heard a lot. Good stuff. Good stuff.
All right, everyone. Thank you so much.
Thank
Thank
You
you.
know how to find
you.
me.
All righty.
Thank
Bye-bye.
you. Nice to
Bye.
see you all.
Bye.
Thanks,
See ya.
Pavithri.
You're welcome.
Bye, ladies, gentlemen. Bye, guys.